Hello and good afternoon, everyone. Thank you for joining us for today's CAS legal webinar on school closure, reopening, and beyond. I'm Bill Silva, Associate Executive Director at the Connecticut Association of Schools. I'm here with two of my colleagues, Karen Pachter, Assistant Executive Director of CAS-CIAC, and Rosie Wojtek O'Brien, Assistant Executive Director at CAS, and our two special guests, attorneys Tom Mooney and Natalia Sieira Millan, from the law firm of Shipman and Goodwin. Before I introduce our guests, we'll go through the ground rules for today. So again, thank you for being here. All participants, except for the panelists, will be muted for the duration of the webinar. There's about an hour presentation that Tom and Natalia will go through with questions that were either submitted or that they've developed. And then there'll be some time at the end for question and answers. And if you can enter your questions in the Q&A at the bottom of your screen. We can go back to that prior slide again. Just make sure I covered all my points. I guess I did. All right, well, I will introduce our guests. Attorney Natalia Sieira Millan is an associate at Shipman and Goodwin and a member of the firm's school law practice group. Natalia is active in all areas of school law and also has extensive pro bono experience and serves on the boards of several local community organizations. A graduate of Boston University and the Quinnipiac University School of Law, Natalia was the Assistant Agency Legal Director with the Connecticut Department of Children and Families and a Connecticut State Superior Court law clerk prior to joining Shipman and Goodwin. Natalia somehow also finds the time to teach school law courses at the University of Connecticut NEAG School of Education and at the School of Education at Quinnipiac University. We're happy to have you here with us today, Natalia, to share your expertise. Welcome. Attorney Tom Mooney, partner at Shipman and Goodwin, probably needs no introduction to most of the folks who are attending. Tom's universally recognized as the expert on Connecticut school law, literally having written the book on the subject, A Practical Guide to Connecticut School Law, now in its 9th edition. In addition to his extensive practice in all areas of school law, Tom teaches at the University of Connecticut School of Law and serves as professor in residence at the NEAG School of Education at the University of Connecticut. A graduate of Yale College and Harvard Law School, Tom has been recognized for his many and notable contributions to education in Connecticut by the Connecticut Association of Boards of Education, the Connecticut Association of Public School Superintendents, and of course by us at CAS. We are proud to feature Tom's legal mailbag column in our weekly CAS News Blast, where with his always lively combination of legal acumen and wit, Tom explores the ever-changing and never dull landscape of Connecticut school law. So I know we're in for a treat today as Tom and Natalia answer the many questions that we all have about what Connecticut schools will look like this fall. So welcome, Tom and Natalia. Thank you for being here. And I turn the presentation over to you.
Thank you for those kind words. And it's nice to talk with all of you. I usually say it's nice to see all of you, but that's not possible this time. So we'll do our best through this process. I do also want to start by thanking many of you for submitting questions. The format for the presentation is that Natalia and I will go through 10 questions and do our best to give you 10 answers and leave time at the end for further discussion and questions that Bill Silva will be monitoring. So I know that the primary question on everyone's mind is the first question, which is, what are the State Department of Education guidelines for reopening school this fall? And I'd like to start by saying that we don't know and don't have a clue. And so those of you who have come to this webinar for that purpose, you might find an hour of free time now because you're not going to get that information today. We do expect these guidelines to come out soon. And when they do, we'll have something to go by. And we look forward to seeing what guidance we receive. And we're all going to do our best to implement education in accordance with those guidelines. But for right now, we have a number of other questions. for which we do have answers. And we'll move on to question 1, the real one. So the question was posed: if the guidelines for reopening in the fall are anything like the guidelines for summer school, good luck to us. How much should I worry if we don't follow all of the guidelines and a student claims that he contracted COVID from another student? So that's the question we'd like to start with. And I'll start with the observation that anyone can sue anyone for anything. And so we can't predict that there won't be litigation here, but what we do want to do is share with you our view that given the importance of reopening and education, we should not make liability a primary concern. We do note that, as I think most of the observers at this webinar are educators, that whenever we talk about liability, we're not talking about personal liability, but rather we're talking about district liability. There's an important public policy protecting educators in Connecticut, not only against liability claims, but providing for attorney's fees so that people don't go broke defending themselves if claims are made. So the discussion here is really over when district liability will be imposed. And the liability analysis, and some of you have probably heard me say this, starts with the question of, have I acted reasonably? Because when you act reasonably, you can never be liable. When you act unreasonably, then liability is a possibility. And it's very important to recognize that whatever the guidelines are, not only issued by the state, but the local rules that you all establish for reopening will be the definition of what's reasonable. So when you don't follow your own rules, you're acting unreasonably, and then the next question is asked, and that is, will therefore there be liability imposed? And the next question then, though, is when someone acts unreasonably, did they cause an injury? And if they didn't cause an injury, then there will be no liability. In the case of COVID, it'll be interesting, and you never want to hear your lawyer say that. It'll be interesting, but it'll be interesting to see how issues of causation are handled in the inevitable event that people bring legal claims that they contracted COVID from whether it's a school or church or what have you. So those are some of our first thoughts on the issue of guidelines, where they play into it, and whether we should worry about liability. So I'll turn it over to Natalia for question 2.
Hi, everyone. Thanks, Tom. So let's go to question 2. Thank you, Karen. So we can't imagine how we can get through buses operating to follow social distancing guidelines. Can we require the parents drive their children to school when school reopens? If not, can we at least encourage parents to drive their children to school and plan routes accordingly? So the answer to this is no, and also yes. Social distancing during transportation is one of the greatest challenges educators are going to face this fall, and the fewer students district have to transport, the better. However, under Connecticut law, each local and regional board of education has to furnish transportation or otherwise school accommodations to resident children. Indeed, parents can claim a denial of school accommodations based on transportation issues, even bus stop placement. As many of you might know, Connecticut General Statute 10-220A requires the states that school districts must make such provisions as will enable each child or school age residing in the district to attend some public day school for the period required by law, and provide for the transportation of children wherever transportation is reasonable and desirable. Thus, the key to the duty to provide transportation is that it must be a necessary part of school accommodations. If a student does not need transportation in order to have reasonable access to school, then there is no duty to provide it. That being said, parents may, and often do, voluntarily drive their children to and from schools. So school officials may poll parents and obtain commitments from some parents that they will drive their children to school, and they may then plan bus routes accordingly. But situations might change, however, and parents will be able to rescind those agreements to be responsible for transportation. So you have to keep a lookout for that. The other question that we thought about as we were answering this one specific question was whether suspension of transportation privileges is something for school districts to consider. And the one thing we just want to remind everybody of today is that enforcement of social distancing and wearing of PPE should not be the name of the game as we enter the fall. You have to consider the implications before reacting to those situations. As you'll see, some students may have no other means of getting to school. And by suspending their transportation services for not wearing a mask or for not being socially distant, school districts may risk exacerbating the education gap. So that's my answer to number 2, and I will turn it over to Tom for question number 3.
Thank you, Natalia. Question 3, whatever the guidelines will be, I'm sure there will be safety protocols. Do we have the authority to discipline students and staff who don't comply? How about parents? So when we look at that, we start with the premise that school officials have the right to establish reasonable rules. And one of the fundamental interests in the school setting is safety. So we are confident that you'll be able to establish these rules in the interest of safety. And if they were ever challenged, that the courts would defer to the judgment of school officials. Here, we do expect that some of these safety protocols will be directed by the guidelines from the State Department of Education and or from the local public health officials. And as we discussed under question 1, when those rules are established, it's important that they be followed, because not to do so is an issue of unreasonable action and potential liability. That all said, we hope that these guidelines are reasonable and that the safety protocols are realistic. We don't want to spend all of our time focused on compliance, and rather we hope that educators can do their job in educating without being overly distracted by these important safety protocols. When you look at students, we do see that you do have the right to discipline students if they don't participate. But as Natalia said with regard to bus transportation, disciplining students for not complying with safety protocols is a last resort. And we hope that first, the protocols will be workable, and second, that there will be compliance without the necessity for significant discipline. With regard to staff, similarly, because school districts can establish these rules, staff will be required to follow the rules. And in this regard, we have the following observations. First, when we establish safety protocols, we have to be sensitive to the possibility that the school district has changed working conditions. And now we're in the area of collective bargaining, because when working conditions are changed, then there may be the requirement for some sort of negotiation. In this case, the change in working rules would most likely be externally driven by protocols from the state or from local health officials. And whenever we talk about changes in working conditions and dealing with a particular situation, it's important when unions make their claims that bargaining should occur, that we differentiate between what we call decisional bargaining and impact bargaining. And sometimes when we want to change a working condition, like we want to impose new restrictions on personal leave, that would be decisional bargaining. We have to negotiate over whether we change that working condition. But in this case with safety protocols, and given their imposition really externally from the state or health officials, that wouldn't be a matter for negotiation. What would be the matter for negotiation is the impact on employees. How does it affect them? And hopefully everyone will be fine and there won't be a claim, but that would be the framework for dealing with union claims relative to safety protocols. But once those protocols are in place, and if people don't follow them, then they may be held accountable. And in that regard, we just want to offer our standard admonition, and that is that disciplining employees is a serious matter, and you always want to make sure you have the story straight before you take any action. So anytime you're concerned about an employee being out of compliance with a particular protocol such that you're concerned and you need to address it, then you need to talk to that employee and find out what he or she says about the situation before you take any action. And finally, the question says, what about parents? We don't have supervisory authority over parents, do we? And the answer is you do when parents enter the school setting. And as we know from the recent changes in protocols around safety and access to the school property, that is a condition that school officials can impose. If a parent wants to enter the building, they have to go to the front desk and they have to sign in. And in this regard, consistency is critically important. When you have rules and some parents are given a pass and other parents are required to follow the rules, then that's a problem. So it's important once these protocols and guidelines are in place that everyone be held to the same standard. So those are our thoughts on question 3. And I'll...
Tom, can I just interrupt for a second? There are a couple questions that are on this point. One is would having paraeducators take student temperatures be a change in working conditions?
Well, we're going to talk about temperature taking, but not in that regard. So I'm happy to answer that question. And we would ask, have they had to do that before? And the answer is most probably not. And then we ask, well, what is how does that impinge upon the working life of that para? And is it a de minimis change or is it significant? And if it's more than de minimis, then that would be an invitation to discuss that responsibility. But in that regard, just to negotiate on the fly here a little bit, I would say, fine, you got to do it. That's externally driven. We're not going to negotiate over whether you take temperatures. Now the question is, what's the impact on you? Is that taking you away from other things that you do? Do we need to look at your workload? So that would be the nature of the discussion, but it's a very good question and I appreciate it.
Thank you.
Was there another question or is that...
There was one about fears of staff members of contracting COVID.
Oh, and we got that covered. We have several questions on that because that is such an important point. So there's more to come.
Thank you.
Okay, and so now if we could go to question 4, I'm going to address that one as well. And question 4 is, I presume that we're going to have to reduce class sizes to maintain social distancing. Will be, speaking of paraprofessionals, will we be able to assign paraprofessionals to teach groups of students independently? And as we've just discussed, if paraprofessionals have not been doing that, that would be a change in working conditions and there may be a need to negotiate about that. The main concern we have in this regard is that regarding teacher certification. And we hope that with the guidelines and with due regard for the need to maintain social distance and perhaps break students up into smaller groups, that through the guidance, we will get some relief from the certification requirements. But right now we have to be aware of the fact that paraprofessionals are generally not permitted to teach groups of students independently. We have a state regulation on this point, and the state and by the way, when this is over, we're going to post on the CAS website our notes and our answers, And and they'll be more detailed than we're able to do verbally here. So I'm going to refer to a regulation, but you don't have to worry about the citation because that will be in the materials. But the state certification regulations do require that appropriate certification be maintained by any person who, and then there are 4 situations, who is not directly supervised in the delivery of instructional services by a certified professional, or who is responsible for the planning of the instructional program for a student, or who evaluates student progress, or who does not receive specific directions from his or her supervising teacher or administrator that constitute a lesson plan for each lesson. So if the task for the paraprofessional is to reinforce learning provided by the teacher, that would be consistent with the certification regulations, and there would not be an issue. That would be maintaining the status quo. But if we separate kids into different rooms, perforce given social distancing, and we expect the person to provide instruction, then we have to worry about certification. And along the spectrum of flexibility, we have to consider not only what flexibility we may have with regard to paraprofessionals supporting the instructional program, but what flexibility we might have with regard to other teachers who are redeployed outside of their certification area to provide instruction to students. And it may be that there'd be more willingness to provide flexibility relative to other teachers providing instruction in this challenging time than there would paras. But that's a bit of an open question. For right now, we want to tell you what the rules are and make sure that we keep those rules in mind as we plan for instruction in the fall. So that's gets us to question 5, and I'll turn it back over to Natalia.
Just to follow up on that, a question came in, or a comment. Could that reassignment of duties be potentially grievable by teachers?
Well, it's unlikely to be a grievance because a grievance would relate to an alleged violation of a term of a collective bargaining agreement. I don't want to give anyone any bad ideas, but if someone were concerned about the reassignment of duties and the claim would then be a unilateral change in working conditions, and the way that would be reviewed is through a complaint to the State Board of Labor Relations. But we'd certainly have discussion before that happens, because the requirement would be for the union to demand negotiation over that different assignment. And every situation has to be considered on its merits, but that would be the avenue. The demand to bargain would be made. We'd decide whether to agree or not to agree. And if there's a dispute over whether we have bargained appropriately, then that would be determined not through the grievance procedure, but rather through a complaint to the State Board of Labor Relations.
Thank you.
Natalia.
Perfect. So just to set the record straight, I thought I might just add how bizarre it is to have 200 of you on the other side and not see your lovely faces and be able to react to your questions. It's very painful, and as I'm sure it's painfully obvious to all of you that at times, if not most of the time, we're reading from a script because we're not used to not having your lovely interaction. So I'll move on to question 5, which I think is one that has been on the minds of many of you for quite some time. Can an employee go out on sick leave in the fall because of fear of contracted COVID-19? So as employees are integrated back into the workplace, there are going to be employees who feel uncomfortable returning to district buildings. There's no doubt about that. Generally, employees who do not want to return to work due to a generalized fear of exposure to COVID-19 are not going to be entitled to paid or unpaid federal leave. However, while an employee may not be eligible for leave under federal law, an employee exhibiting generalized fear could be entitled to use any accrued leave that is otherwise available to him or to her if it is available for such purposes under the district's leave policies and the relevant collective bargaining agreement. Additionally, qualifying employees with disabilities may also be entitled to receive reasonable accommodations under the ADA. So we have to be very mindful as you navigate these next couple of months to remember that any employee with disabilities could be entitled to receive a reasonable accommodation. As you know, the ADA requires employers to provide reasonable accommodations to those employees that are qualified and applicants with disabilities, unless doing so would cause an undue hardship. So in general, an employee must request an adjustment or change of work due to his or her medical condition. And then we start this dialogue about accommodations and what is reasonable and is not reasonable. I will note that the EEOC has stated that during the pandemic, employers may ask questions to determine whether an employee's condition is a disability and request medical documentation if needed. If a disability is obvious or already known. You're also able to discuss with the employee how the requested accommodations would assist the employee and enable him or her to keep working. So when we're talking about a dialogue, those are certainly reasonable questions for the employer to ask. And also the EEOC notes that we should explore alternative accommodations that may effectively meet the employee's needs during this pandemic. Employees whose disabilities put them at a greater risk of COVID may request accommodations to reduce or eliminate altogether the risk of possible exposure. I'm sure some of you have already experienced those requests. In response to the pandemic and in accordance with summer school rules, some changes that reduce contact with others will likely be implemented for all employees. Such as physical distancing, personal protective equipment, and other things. And additional accommodations that may be considered may include one-way hallways or plexiglass barriers around the employee's desk. So in addition to all of that, the EEOC has given us tremendous guidance, offering suggestions such as temporary job restructuring, marginal job duties, temporary transfers to different positions, or simply modifying a work schedule or shift assignment to permit individuals with disabilities to safely perform the essential functions of their job. So if possible, allowing an employee to telework could also be a reasonable accommodation under these circumstances. So I think the bottom line to question number 5 is school officials just have to evaluate the situation of each employee on an individual basis. And I think Tom mentioned earlier, flexibility is really going to be the name of the game as we enter the fall. So with that, I am ready to move to—
Can I ask a somewhat related follow-up? In order to, I guess, encourage or ensure use of PPE, should school districts purchase all of the required protective, whether it's masks or sanitizers or the rest, in order to, if they're going to ask people to use these, should then they provide them?
That is a very good question, and Tom, feel free to jump in at any time. But the most recent summer guidance from the State Department of Education does actually require boards of education to provide PPE. If the teachers or any other staff member or the students have it, they're welcome to use their own, but it needs to be available. There need to be appropriate cleaning procedures in place, and hand sanitizer, like you mentioned, is something that should be readily available. Do you have any additional thoughts, Tom?
Yeah, I would just say that that's all right on target, and I would just say that the question is, do we think this is necessary? And as soon as we say it's necessary, then it's going to be a district responsibility. And then individual employees may choose, just as with instructional materials. The basic instructional materials are provided, but a teacher may go out and buy other things. So similarly, a teacher or administrator may decide to purchase additional PPE or something they prefer, but it will be a district responsibility to provide anything that's necessary.
And this is a kind of a related follow-up to what Natalia was speaking about in terms of staff members in fear of contracting COVID. And the question is age over 60 or 65 a qualifying disability? under in terms of contracting the disease?
Remember when I told you when we were practicing that I was terrified of this being recorded? This is this is why. So
speaking as a person in the target group, myself disabled, but that claim could be made. That it wouldn't be a disability per se, but it would be a concern that they could raise seeking some sort of protection that they would claim to be especially susceptible. But I'm sorry, Natalia, you were going to say something?
I was just simply going to mention that we have to be careful as we get these requests, not to think that it's easier to just make blanket decisions about certain category of individuals, because we may fall into discrimination areas that we can't get ourselves out of, right? So just because we should deal with any of these requests for accommodations on an individual basis so that nobody can claim that we have a rule that's discriminatory, because there might be individuals over the age of 65 that are perfectly comfortable coming to work, and keeping them from doing so would be discriminatory in nature.
So the follow-up to that is, do you ask or do you wait till the employee raises it him or herself? Do you put the question out there in a survey, or do you wait till?
I wouldn't go looking for trouble.
Mm-hmm.
Okay.
I think, Natalia, you said that the EEOC is more flexible in terms of reaching out to employees in this circumstance and asking questions, because the general rule is that we deal with people as they present, and we don't go inquiring as to what health issues they have or what medication they're on. That's none of our business unless and until they say they have a disabling condition that affects their ability to do their work. And in that circumstance, then we respond to that question by them. And the normal rule is we don't go asking people about their disabilities. There is a little more flexibility here under the EEOC rules, but I wouldn't see any particular need or advantage to surveying employees, because as you sometimes hear, be careful of the question you ask, because you may not want the answer you get. And so I would keep my head down and wait for the questions to come in from the employee.
And I guess another follow-up to that, is HIPAA involved or applicable in these situations in terms of employees sharing medical conditions and that type of thing?
Well, Natalia and I talked about this briefly, and I think it's obvious looking at us that we're not HIPAA but HIPAA applies to health providers. And if you're a health provider in a school setting, compliance with FERPA is deemed to be compliance with HIPAA. But, or maybe it's the reverse, it's compliance with HIPAA is deemed compliance with FERPA. But most school districts are not health providers, and so they're not involved with HIPAA issues. It is more the FERPA issues that would be involved.
Thank you.
I think you're up, Natalia.
Are those the questions? There's no more questions on 5?
No.
Okay, terrific. So let's move to question 6. So how about employees who want to care for a loved one? Can they go out on sick leave? So this is a bit complicated, and when we were trying to figure out where we would be by the time we reached question 6, we thought it would be right at 3:30, and I see that we're at 3:38, so I'm going to try to cover it as quickly as I can. But I just wanted to remind you of a point that Tom made earlier, which is the answers to all of these questions will be available to you after this webinar. So if I don't cover it, there'll be more detailed responses in a document that will be provided to you later. So in response to that question is employees exhibiting a generalized fear, as I mentioned earlier, or anxiety about returning to work and potential exposure, perhaps because they live with a family member who's particularly vulnerable to the disease, are not generally entitled to paid or unpaid federal leave, right? So that's going to be your baseline. That being said, they could be entitled, just like under question 5, to any accrued leave that is otherwise available to that individual under the district's leave policies and under the relevant collective bargaining agreement, right? In addition, you have to be mindful, and I'm sure you're sick and tired by now of hearing about the Families First Coronavirus Act, that an employee who is unable to work because he or she is caring for an individual who has been subject to a federal, state, or local quarantine or an isolation order, or has been advised by a healthcare provider to self-quarantine, may be entitled up to 80 hours of paid sick leave under the Families First Coronavirus Act. And I'll go into detail just in a few minutes about the interplay between that, those 80 hours and the FMLA plus, as we now colloquially call it. But it's important to remember that the individual requiring care must actually depend on the employee for care. So if an employee is saying that their 80-year-old grandmother needs to be cared for by that individual, that person, that teacher that may be making the request, must actually be the one person that the grandmother depends on, right? It could be an immediate family member, an individual who regularly resides in the employee's home, or an individual for whom the employee's relationship creates an expectation generally that the employee would care for that individual during a quarantine or self-quarantine situation, right? But finally, if an employee needs to care for his or her spouse, child, or parent who have a serious health condition as defined under the Family and Medical Leave, the regular FMLA, the employee may be entitled also to leave under the traditional FMLA rules. So let me just give you a little tiny overview of this Families First Coronavirus Response Act, because it's something that should be in the back of your mind as you navigate some of these requests from employees. So the FFCRA, as we refer to it, provides for emergency paid leave in certain circumstances, and that leave is available between April 1st of 2020 through December 1st of 2020. There are 2 types of leave available under the FFCRA and are provided through the Emergency Paid Sick Leave Act, which is EPSLA, and 2, the Emergency Family and Medical Leave Expansion Act, which is the FMLA plus. Both leave provisions are available to employees who are unable to work or telework for a specific qualifying reason. And I'll quickly go through the 6 reasons that entitle you to those 80 hours of paid sick leave. So the first one is the employee is subject to that federal, state, or local quarantine or isolation order. The second one is that the employee has been advised by a healthcare provider to self-quarantine. The third is that the employee is experiencing symptoms of COVID and is seeking medical diagnoses. And the employee is caring for an individual quarantined, as described in 1 and 2. 5, the employee is caring for his or her child whose school or place of care has been closed or child care provider is unavailable for reasons related to COVID, and this will be important in just a minute. And number 6 is that the employee is experiencing any other substantially similar condition specified by the U.S. Department of Health and Human Services. Now, I couldn't tell you for the life of me what the 6th one is. There's been extremely complicated guidance issued to sort of help us navigate these provisions. But number 6 is one that still, as far as I know, remains a mystery to us. We don't know what a substantially similar condition means. So there are caps for both EPSLA and the FMLA plus, and those will be in your materials, so you can reference those. But the second element of the FFCRA is that FMLA plus. And the reason why I mentioned that number 5 would become relevant, number 5 under EPSLA will become relevant under the FMLA plus, is that FMLA plus is only available to individuals that need the leave because the employee can't work or telework because he or she needs to care for a minor child due to closure of the child's school or place of care. So while the first 80 hours are available to an employee that meets any of the 6 qualifying conditions, FMLA plus is only available for this one specific condition. And there's, in your materials, you'll see there's an interesting interplay between FMLA and EPSLA. Under the FMLA plus, the first 2 weeks are not paid. and the next 10 weeks are paid at 2/3. But there are interesting considerations that I hope you'll enjoy reading in your materials. But I'll just tell you very briefly that, again, the name of the game is going to be flexibility. If the employee has accrued significant time off or any time off and is available to him or her, districts should consider providing that available accrued time off to the employee, because recognizing that there's a very human impact to this whole pandemic is something that Congress was very much aware of. So flexibility will definitely be something to consider as you get into the fall. So with that, I'll leave Tom with question 7.
Just a quick follow-up on this same topic. If a person needs to be quarantined for the 2 weeks and meets the requirements, would they use sick time, their sick time, or would it be the 80 hours that's provided to them through the act that you mentioned? So would it take their sick time away?
So that's a very good question. I very much appreciate an opportunity to sort of shed whatever light I can on the topic. The guidance is unclear. And generally, we've been advising districts to be flexible. And what we mean by that is if somebody becomes sick as a result of COVID, they shouldn't necessarily have to lose all of the days they've accrued. For quite some time. Imagine somebody has 150 sick days because they have, an exceptional attendance record. It would be almost cruel to subject somebody or to require somebody to use up their sick bank. That being said, it still remains a business judgment. I don't know if Tom has anything to add on the issue, but the FFCRA, the spirit of it in any event, is meant to give employees a lot of flexibility, right? So under this new law, you have 80 hours of paid time that districts have to provide you, whether you have the time or not. So if you flip the question and you ask me the question of if an employee doesn't have any sick leave, are they still entitled to those 80 hours paid? And the answer to that is yes. So I would just, focus on the spirit of the law, which is to provide families as much support as we could possibly give them during a difficult time.
Thank you.
And I just want to thank Natalia for an excellent summary of a very complicated issue. And I think in every case, we're going to have to look at the statute and hear the particulars of the factual situation and then advise. This is something Congress made quite complicated, and we'll want to look at it carefully. But for as complex as it is, I wanted to thank Natalia for that great summary, and again, refer to the materials. There's more material on this one question than any other question in the material. So question 7, not to be cynical. I've already heard that some teachers have decided not to come back in the fall, one way or the other. Can teachers insist on teaching remotely because of health concerns? And of course, the answer is it depends. So we always have to look at the individual factual circumstances. But we start with the premise that teachers do not have the right to assign themselves to a particular position. We, as a management issue, make assignments, subject, of course, to collective bargaining provisions. But the contracts that impinge upon management right to assign teachers are rare. The general rule is that we would assign teachers. That said, and before we get back to the individual teacher who doesn't want to come back and who wants to stay on some sort of remote instruction assignment, the question for school districts is, should you create such positions? If you don't have such a position, then there's no issue. But should you create these positions? And there are a lot of questions about the fall, and that's one of them. But I would predict that most, if not all, school districts will have some remote teaching positions in their districts in the fall, not because teachers need to teach remotely, but rather because some students will not be able to come back into the school setting. And once that position exists, then who gets the position will be considered through both collective bargaining rules and the issues of reasonable accommodation under the ADA. If a teacher presents and says, I am health compromised, I can't come back at this time, you have a remote teaching position and I want it. That's the beginning of a conversation, and it may be that through an interactive dialogue, you accept the teacher's premise in terms of the health condition, and this is a logical assignment for that teacher. But I do want to emphasize that creating positions is not part of the accommodation process. So if you don't have those positions, or if you don't have enough of those positions, through the accommodation process, you're not going to be required to create them. But when we're trying to figure it all out and make sure that we serve all of the students, irrespective of their health issues, then we may well end up with some of these remote teaching positions, and it would make sense to consider teachers first who have some justifiable reason for wanting the position relative to the duty to accommodate. So that gets us to question 8.
Okay. Bill, I see there were a couple of questions. I didn't know whether we wanted to address them.
I think they're coming up because most of them are about students, and I know the next set of questions are about parents and students.
Terrific. All right, so I'll move on to question 8. So some parents are squirrely about the reopening in the fall as well. Can they insist on our continuing to provide remote instruction to their children instead of sending their children back to school in the fall? So the answer to that is no, except maybe. So we will have to wait and see what instruction will look like in the fall, but we anticipate that there will be a component of in-person learning. So generally, parents cannot insist that the district provide remote instruction to their children instead of sending their children back to school. However, they could possibly insist if their doctor presents medical documentation, right? So if a doctor attests that a student's medical condition prevents him or her from attending school, remote instruction for that student could be an accommodation for a medical condition functioning as homebound instruction. Generally, as you know, school districts must provide homebound instruction to students in public schools under their jurisdiction when students are unable to attend school due to a verified medical condition, which may include mental health issues. Under Connecticut State Agency's Regulation 10-7060-15, and as Tom mentioned, no point in writing this down because it'll be in your materials, school districts are required to provide homebound instruction when a student's treating physician provides a written statement directly to the school district on the district's form stating the following: A, that the student's treating physician has consulted with school health supervisory personnel and has determined that attendance at school with reasonable accommodations is not feasible. B, that the student is unable to attend school due to a verified medical reason. C, the student's diagnosis with supporting documentation. D, the student will be absent from school for at least 10 consecutive school days, or the student's condition is such that the student may be required to be absent from school for short repeated periods of time during the school year. And the last thing is that they need to include the expected date the student will be able to return to school. So provided that all applicable requirements have been met, homebound instruction must begin no later than the 11th day of a student's absence. However, the school district can also agree to begin instruction earlier. So when I said that the answer is no, except maybe, I really meant it. Generally, the answer is no. However, if we have medical documentation that supports the request, it would just simply be an accommodation to a medical condition. So with that, I give you Tom.
And could that change? I mean, as circumstances change, so could a student start, because of a medically necessary situation, start out through remote learning, but then, I guess in consultation with the school, change so that the student attends in person. So it's not one or the other for the whole school year. It can change over the course of the school year potentially.
Well, I presume so, and I obviously I defer to Tom if he has any further comment. But typically with homebound instruction, some kids get better sooner than expected, right? And so it would just be a matter of having a conversation with the parent, or the parents making the request for the child to come back sooner, and perhaps seeking medical documentation that supports the reintroduction to in-person instruction for that particular student. It's going to depend on the factual situation of every single request, just because the condition of every student might be different, right? Where a student is simply afraid, and so from a mental health perspective, a treating physician made a determination that the student should not go back, at least initially, until he or she feels comfortable. That's different than a student whose immune system is significantly compromised and may be unable to return, period, right? So I think we just have to make assessments as the questions arise. But I certainly can see somebody returning sooner than expected, with the appropriate supporting documentation.
Thank you.
Just to supplement that, I see in the chat, the question refers to a parent who elects to have a child stay home. Can that parent later change his or her mind to allow the child to return to school? And I think, as we've discussed, parents don't really have the right to elect without more. But if a parent does present medical documentation, as Natalia said, to justify a homebound instruction, and then that circumstance changes, well, then there would be no justification for continued remote instruction, and that student would be welcomed back into the school environment as any other student. So it's not an irrevocable decision when the year starts. Anything else on that?
So it says, should schools be proactive about seeking out students who might have medical condition that would put them at risk? So it's kind of like the previous question. Do they go looking for these situations with students, or do they wait for the situations to be brought to them?
Well, that's a really good question. And I would just be practical about it. And that is that the general rule is that we don't do asking kids, how you feeling today. And so I would generally say we shouldn't be surveying or asking questions and perhaps raising questions when none exist. But sometimes the circumstances are evident. And if something's squarely in front of us and we're not noticing, then that could be a problem. So the general rule is that we don't go asking unless we have a reason to ask. And if we have a reason to ask, we should. And based on the information we provide, then we're going to take the appropriate action when we do ask. So it's with so much of this, it's focused on the individual factual circumstances and trying to act in a reasonable way that promotes student and staff welfare. So question 9 is, if a student shows up with an elevated temperature but says she feels fine, what authority do we have to tell the student to go home? How would that work anyway? And I must say that the biggest lesson I've learned from living in COVID Connecticut for the last 3 months is that health concerns hold a special place in our legal system. And I mean, you might have thought we lived in a democracy and where laws are passed and conduct is regulated through a legislative process. And I don't know how many executive orders we're up to now, but I think it's in excess of 30, maybe 50. I don't know. Maybe, But, and it's a little bit like the Middle Ages when the king would just, write something and stamp it with wax, and that's the new rule. And these health rules are kind of like that. We're just told, this is the rule, this is what you have to do. And I'm not saying that in a critical way. it just underscores the fact, under what authority do we have to tell that student to stay home? Well, under the general guidance of the state and or our local health director, who has enormous power because of the importance of public health. And in this particular case, as some of, or perhaps all of you know from the summer rules, temperature screening was required or is required. I guess it hasn't even started yet. It's July 6th. It's going to be required for attending summer sessions. And so we'll wait to see what the rules are in the fall. But I'm pretty confident that the guidelines will require some sort of temperature screening. And if a student presents with an elevated temperature, we're going to have to take that student under special control. And under the summer rules, school districts are supposed to have an isolation room where children who present with symptoms are held pending the pickup. Actually, it says students and staff who present with potential symptoms. So in this particular case, I think we will have the authority to tell that student that she has to go home. We will have the responsibility to place that student in isolation in some manner. And we would have the responsibility for making sure that that student is safely transported home, presumably through a parent or caregiver. So that's our answer to question 9, and that gets us.
So a couple related follow-ups to that. If cases of COVID are confirmed in a student or an employee, staff member who presents symptomatically, then what happens?
Well, that's going to be an important part of the guidance. The summer guidance is a harbinger of what we may expect. But under the summer guidance, school officials are required immediately to notify the public health director for that particular school district. And there would be the potential for shutting down the program. There would be the potential for contract tracing and figuring it out. So the presence of a COVID positive person in the school setting could well affect operation on some sort of temporary basis. But that's going to be the function of the guidance we receive and the directives of the local health officials when that happens. I do expect it to be taken seriously though. And at that point, and by the way, the summer guidance does not impose upon school districts contact tracing requirements. That is a public health issue, but we will make sure that we know exactly what the rules are relative to positive cases that are found in the school setting.
So just to clarify, so it hasn't been specified or spelled out yet what would happen, but it would be up to the health department to make those determinations?
Well, it's spelled out in the summer guidance, and it's quite clearly stated that if there's a positive case, you have to notify the health director, and there may be a shutdown of that program for some period of time. What the uncertainty is, where we started with fake question 1, what are the guidelines? And the answer is we don't know yet, but we do expect this to be an important part of the guidelines because we're obviously, there's risk in all we do, and obviously education is critically important. There will be risks involved in opening in the fall, but we need to educate children. And those guidelines in terms of, well, what happens when will be critically important. And what happens when a positive COVID case is disclosed, then we're going to have to do something, and we await that guidance.
And you said about informing the health department. Is there any duty or responsibility to inform beyond that? Do you inform parents?
The guidelines talk about that, and every case is going to be done, specifically and individually, but the expectation would be that, and this is where it's going to be a little tough. It says consistent with FERPA, which protects confidentiality of student information. The parents and employees who are exposed should be notified. And there may be then an expectation of quarantine for those exposed individuals. We just don't know what the rules are going to be. And this is a moving target. What's reasonable for the summer of 2020 may not be, or we hope is not reasonable for the summer of 2021. And where along that continuum we land for the fall, we don't know. But there will be a guidance on that. And the expectation I have is that if positive cases are discovered, the potentially exposed people will be notified.
This is kind of a technical question, but it's related to this topic. Is there a student privacy issue if a school uses a therma camera with facial recognition?
I'll get back to you on that one.
Okay.
I don't, facial recognition, thermal. I mean, if I
think we punt.
Yeah.
All right.
That one they're going to have to pay for.
Right. Maybe the guidance will tell them.
We can hope. Okay, question 10.
Okay. So before I answer this question, please don't ask any follow-up questions because special education is not my forte. So you will also have to pay for those answers. So question 10. I have serious doubt that some children with disabilities will be able to follow safety protocols. Will we be able to tell parents that we will have to provide remote education to those children? So this is a very complicated question. So some special education students and elementary school kids are just not going to be able to comply with safety protocols. That's the reality that we're going to have to live in, which is why earlier in the conversation, we noted that enforcement should not really be the name of the game as we approach the fall. So whether in the summer and the fall, we're going to have students who just won't be able to wear masks faithfully or to maintain social distance, right? Some special education students or young students will most likely share materials or take materials away from each other, and we're just going to have to deal with that reality. So we think that what's critical here is that school officials work with the local health director to decide on what is and what is not safe. If the local public health director determines that specific students' conduct is unsafe, remote instruction may be a reasonable alternative, right? However, if a school is otherwise open, for children with disabilities, the PPT should consider the issue and change of placement rules may apply. It might be helpful to frame the message as follows. On the recommendation of the health director, your child can't come for in-person instruction unless we can address these safety issues. Right? Districts may want to also consider creating videos. We've heard of different districts that have created videos for families that show how to get children to tolerate a mask, and they have plenty of time over the summer to generate activities around that. So perhaps it would be helpful to send home some videos that helps build what you want your safety practices to be in the fall. We also know of at least one health director who has recommended COVID testing for every staff person who is going to work in and participate in an ESY program, and then periodically throughout for kids who are in small self-contained programs, right? So those small environments with more significant disabilities. But it might also be helpful to bring your health director in to see what the physical space looks like, right? It's always easier to plan in person if that individual knows what you're talking about, and you can tell him or her, well, I want to put 10 or 20 kids in this space. Is that safe? Right? It'll be very helpful to sort of bring them into the space that you want to restructure or plan safely around so that they can give you better guidance. So that is the answer to question 10. And again, I am not taking any questions.
Well, we can
Lucky you, no follow-ups came in. So I could make up some, but
I'd rather you not.
Right.
I think we've been able to answer some of the questions posed by participants on the fly, and we're here at 10 minutes after 4. So I think the timing has worked out well, and
Yes.
we hope
There are a few questions that I noted that I said I would get back to folks on, so
okay.
I could bring those up.
Please.
One has to do with use of personal protective equipment. If the district, as you said, the district is obligated to purchase it, if the district provides it, is that what must be used? And the question came up, could a staff member be liable if the staff member wears a homemade cloth mask when proper PPE is provided by the district?
Mhm. Well, I think you're going to want to decide as a district what you want to do. I am reluctant just in general to say that we're going to tell people they can't use their own PPE, but maybe that is the simplest solution. What I can tell you unequivocally is that we have the right to tell people they can't use some jury-rigged PPE that people come in with. But there may be circumstances where a teacher or other school employee has an alternative, which we think is just fine. And if we do, then there's no issue, and we can let that person do it. But we do have a responsibility to make sure that people are following the rules. And if a homemade PPE doesn't fit the bill, then we would be required to tell that person, no, you need to use the official PPE. And even as I say that, you know, there's just this general premise in the law that we have general guidance because we can't consider every situation strictly on its own merits. We have age limits on voting, for example, even though younger kids are mature enough to vote. So it may be that a district would want to just say, look, we're not going to get into a negotiation with everyone who has a better idea. We're going to say, this is the PPE and this is what you use. That would be a reasonable solution. I just don't want to be too categorical in giving that answer.
Okay, and I have one other question that came in very early, back when you were talking about transportation. If a parent, and you had said you could ask or encourage parents in terms of providing their own transportation, if a parent does opt out and then a school goes ahead and makes its routes accordingly, can the parent then ask to be back in and included in the transportation? And does the school district then have to readjust their routes to accommodate that change?
I'll defer to Natalia.
I was going to defer to you. We have an obligation to provide reasonable transportation, right? And so to the extent that a parent thought, and this is just my own perspective, again, without giving it sort of on the spot, without having much time to think about it, parents may think at first that they might be able to provide transportation to their kids, and then their work schedule might change as a result of something, right? And then do we really want to be the district that says, well, you didn't sign up at the beginning of the year, so now you're on your own. You got to figure out how to get your kid to school. And then we have a kid walking through the middle of the woods, you know, or some highway to get to school. We also can't create any sort of obstacles or any dangerous and unsafe situations for kids to access schools. So to the extent that it would just exacerbate the education gap and perhaps affect truancy numbers, right? I would think that generally we would have to provide transportation. But again, it would be it would depend on the facts of the situation, right? But I think it would be unreasonable for us to say flat out, nope, you missed your boat. We can't transport your kid now. You're on your own. He or she can walk to school.
A parent could even argue that it's a statutory right, and we can't bind a parent to waiving a statutory right unless we actually contract with them and there's consideration exchanged. But in the general, our general premise here is that parents are going to want to contribute to the solution, and many parents are going to want to transport their kids. That should never work to their detriment. And if and when the circumstances change, or even their minds change, and they say, you know what, I'd rather take you up on your statutory obligation, I think we will have to provide that transportation.
Can the district, impose some time frame? If we'll be able to do that in a week, 2 weeks?
Yes.
Or does it? Okay.
And I'm just being commonsensical about it. If I think that's perfectly reasonable. For any number of reasons, we can exclude kids from school for up to 10 days. I don't take that lightly, but a parent can't expect us to, and this would only be in the circumstance where there is an issue. To the extent we have excess capacity, this could be a tomorrow kind of thing. But if we do have to reallocate responsibilities and reroute something, and it's going to take us a week, we would just tell the parent, it'll take us a week and your child will be provided transportation and when we're able to do that.
Going back to about the district providing PPE, and someone raised the question of the cost of that, and the costs that districts will have to take on in order to provide appropriate and ongoing personal protective equipment. Is that a factor that districts will have to address in some way?
Absolutely. It's just it's a cost of doing business in the fall of 2020. And I know that this is a terrible time in terms of district expenditures, but I don't see any alternative to shifting those costs to employees. And of course, then you're inviting a collective bargaining matter, because that would be a change working condition, and good luck to us. I think we have to just assume the responsibility.
Okay, I think we got one more. Can we suggest students and staff bring their own masks and then provide masks only to those that are unable to provide or bring masks that meet district requirements?
I think that was addressed in the summer guidance, and the answer is yes, you can. If masks are required, then people address that as they see fit, but we have the ultimate responsibility. So as with many places of employment, if the person doesn't have a mask, then we provide a mask if masks are required. I think that would be true of the school setting. And the converse is that if a child shows up with an appropriate mask, that's fine. And when we get into mask quality, there are some, in the guidance, there's some direction in that regard, but it's just basically a barrier between the face and the outside world. I think there's great flexibility. So I don't think, as long as the mask covers the face, I don't think we're going to get into a debate as to the quality of a homemade mask when kids come to school. And that may be the preferred choice for them. I don't know if Natalia, if you had anything else on that.
Even though I'm not a special ed expert, nor do I ever, will I ever claim to be. One thing I think to just note is that there are some kids that may tolerate their own masks much better than being provided masks at school, right? And so where a parent or through some special education services will tolerate a mask better that they've practiced with, that's also something to consider. Throwing a brand new mask every day on a kid may not necessarily be the best way to handle the safety protocols.
Thank you. A question came in. Do schools need to document the daily health checks or the health screenings that they do?
Okay, I think that's another question one, which is we don't know.
Right.
tell you what I think, and no one in this audience should rely on this, okay? Can we understand that? My thought is that you should document your procedures. But let's just take a high school with 500 kids. Are we going to have a ledger of 500 temperatures every day? I hope not. I think what we will want to document is this is our procedure and we follow our procedure. But the guidance may tell us differently, and we may be expected to maintain those records. I certainly hope not.
Great, thank you. Just monitoring another question that's come in. Oh, I know, we just answered that one. If we are to lease a building and move students and staff into that building to maintain social distancing, would that constitute a change in working conditions which may be bargained?
Well, let me take that one because of the collective bargaining implications, and I'll defer to Natalia. But no is the answer, because well, number one, remember decisional bargaining versus impact bargaining. That's clearly not a decisional bargaining issue. If we need to lease space, we lease space. If we need to tell people that's your new place to go to work, then they go to work there. It's really hard for me to imagine an impact that would justify a union demand. But you get into the details, and that's why collective bargaining is so fun. Is there parking? How far do I have to walk? But if it's those are the type of details that we may have to talk about. But the general issue is, no, this is the new workplace, and you report to work there. And then, we want to work cooperatively. We don't want to cause trouble for our employees. So we want to be sensitive to their concerns. As we lease space, we want to consider issues like parking and access and such. But I think unions would be hard pressed to demand any sort of significant bargaining simply because we changed the location of where they do their jobs.
So a question has come in. It's a little complicated. It gets to the issue of asking families and staff about preferences regarding distance learning. If a school waits to kind of get that piecemeal, that puts them in a bad position for planning, while if they ask ahead of time, then they're in a better position for planning. And I mean, you've kind of indicated, don't go looking for problems, but in terms of addressing needs and the school district's need to kind of be aware of what those situations are, how much should they ask families and staff about either their need or desire for distance learning ahead of time so that they can plan accordingly?
That's an excellent example of decision-making in complex situations. And so, I'll stand by my advice, don't go looking for trouble. But if it's going to be more trouble to deal with the unexpected, then you're balancing interests all the time in making these complex decisions. And so I think it's a terrific question and a terrific consideration. And as the decision maker considers, well, what's worse, inviting trouble or planning for the trouble that we're going to have? I think it's a perfectly reasonable decision to say, we know we're going to need to provide remote instruction. We need to get our arms around what that means for us. And so I wouldn't want my prior comments to be interpreted to tell people, oh, don't ever ask. Sometimes that would be the most appropriate course.
Thank you. Okay, well, I do not see, oh, wait a second. just when you think you're off the hook, What are implications for returning part-time? Returning part-time for a district for staff who have children because of a child care issue. Could they use FMLA? So could they ask to return part-time, I guess, as opposed to full-time because of a child care issue? And could they use FMLA?
So they can certainly, if the school is closed, right, or the the child care provider is unavailable to those parents, they certainly can access FMLA Plus, which is those 12 weeks, the first 2 of which are unpaid. There's been significant tension in Washington as to whether you can take FMLA Plus intermittently. I think we've landed in a good place, which is, yes, you can take it intermittently. I don't know whether that would mean a reduced schedule, sort of to supplement the use of FMLA Plus. I don't know, Tom. I don't know how you feel about that, but you certainly can access FMLA for that particular situation. I think as a blanket rule, it might be difficult for districts to just offer that because we have a lot of children to educate. And so if everybody were to be part-time, it'd be very difficult to implement any sort of in-person or remote learning. But it is something that districts may have to consider on an individual basis.
Yeah, I would always start with the premise, what positions do we have available? And just as I mentioned with assignments, people can't tell us what their assignment's going to be. They can't tell us what positions to have. Now, there are certain circumstances, particularly under the ADA, where a limited work schedule may be a reasonable accommodation, but it may not be a reasonable accommodation because we may not be able to fulfill our responsibility to educate children by accommodating that individual preference. So I would say that teachers would be free to ask, and we'd be free to say yes or no. And this is where, and as we come close, I know we have another couple minutes, but as we come close, I think we circle back to a point Natalia has made repeatedly. And that is that as we deal with these unanticipated circumstances and these compelling family circumstances, flexibility really has to be our guideline with due regard for our ultimate responsibility for educating children. And in that regard, we might even want to remember that no good deed goes unpunished. And so if we are, quote, flexible in a particular case, we always want to consider whether we want to protect the district going forward by saying that this is non-precedential, and we would agree to this with the understanding that we're not changing working conditions or creating a past practice. But those circumstances where a teacher wants to work part-time, I think we look at that with the greatest degree possible of flexibility, but ultimately decide what we can do as a school district. And if we want to be super flexible, we might want to protect ourselves with an MOA so we don't have a past practice to worry about when the next person asks.
So this will be our very last question, and it's completely speculative, so probably a good way to end. So the person raises the issue as masks, the wearing of masks, that type of thing has become more politically polarized. And this person assumes that this will inevitably be challenged in a court somewhere. Do you foresee that courts will say that freedoms are being infringed if a staff member, student, or parent complains about the requirement to wear a mask?
I'll defer to Natalia.
But this is a constitutional question. You're my expert on this. I think we have a right to tell people how to be safe within our buildings. I don't know if Tom feels any differently, right? We have a right to require the staff members wear PPE, especially if the Department of Public Health is making that recommendation. I suspect that the guidelines will require that they do so, right? So not complying with those is something that we could certainly address. whether or not courts will make a decision that this somehow infringes on their constitutional rights. I don't see that happening, but I'll let the expert that defer to me answer more concretely.
I would just confirm exactly what you said, that it's a great country, America, and we have a lot of troublemakers who like to file lawsuits. But I think early on we talked about school rules and deference courts have to the establishment of school rules. So it would have to be, I think, an egregious misapplication of common sense before a court would say that an employee's challenge to a rule that was intended to promote public health would be undermined. So I am not at all worried. And if anyone gets sued, you have my phone number.
Well, I have to thank both of you for wonderful presentation, excellent questions and responses. And in the situation where there's as much uncertainty as there is, the fact that you were able to give us such good guidance is really an excellent help, I know, to all of our listeners. So I will just remind folks that to come and to check the CAS website. There's a link up there where you can get a summary, more detailed in some cases in terms of the responses with the citations of regulations and the rest. So please check on that. There will be a recording available as well. So thank you everybody for attending. Thank you very much, attorneys Tom Mooney, Natalia Sieira Millan. Just wonderful to have you. We look forward to having you back at CAS virtually or in real life when those circumstances allow, but it's always a pleasure, and just want to thank you very much, and thank you everybody, and enjoy the rest of your day. Stay safe and take care.
Bye, everybody.
Guys,
Thank you. Thanks. Bye-bye.